This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome to Discussions at the Roundtable. I'm your host, Noah Ballmer, and today's guest is Dean Barron. Now, Mr. Barron is the owner of TwoBlueCats.com, a full-service statistical analysis consulting firm with specialties ranging from regression analysis to Ph.D. thesis preparation. He is a sought-after expert witness with over 25 years of experience, and he is a published author. Mr. Barron holds an MS in statistics from Cal State Long Beach. Mr. Barron, thank you so much for joining me here today at the Roundtable.
Well, pleasure. I appreciate and thank you for inviting me.
Of course. Let's jump into it. You have an impressive background with a career that touches on nearly every aspect of statistical analysis. How did you first get involved in that, and how did that lead to expert witnessing?
So I always felt numbers were my friends, and I always gravitated towards statistics. Even in grade school, long way. So that part was pretty clear to me. But in terms of eventually becoming an expert witness, that was not planned at all. In fact, I was performing some statistics for a bank up in San Francisco. And so I would stay for a few days at a time up in the Bay Area. And I went to there was a synagogue I liked to go to, and I would meet people there. And great, but I don't talk about business. But then I bumped into someone that I knew. And I said to her, I said, by the way, what do you do? And she said, oh, I'm a lawyer. I said, oh, that's interesting. She said, what do you do? I said, well, I'm a statistician. And she paused for a moment and she said, you know, we're losing a court case pretty badly. Would you be able to help us? And I said, well, I'll take a look. And if I can help you, I'll help you. And if not, I'll try to find someone that I can suggest that you contact. And she said, okay, that sounds fair. Thankfully, not only was I able to help, it turned the entire case around, and they wound up very favorably resolving the case. And then they referred more cases, and then they had colleagues and compatriots. And so really, that was how it started.
That sounds like a really excellent first experience. Although you did kind of hit the ground running with a case that was quote unquote already losing. Let me ask you first, before we talk about the case, let's step back to kind of the vetting process. You know, what sorts of questions did they ask?
Well, that very first case probably was not typical because they knew that I hadn't done statistics expert witness, so there were no conflicts of interest, and they were losing. So they knew either I could help them or I couldn't, and there really wasn't much else to ask. Typically for a new case, of course, conflicts of interest. Is it something that I have an expertise in? And it doesn't have to be, and I guess this is a general thing, I think whatever someone is an expert witness in, it's a good thing to continue consulting professionally outside of jurisprudence, because there are things that never come up or don't typically come up in a court case, but you would pick it up if you're doing consulting and an analysis. And I'm sure that it's similar for other fields of expertise as well.
So staying engaged in your profession is important to being an expert witness?
It is. And I definitely think it's important to continue whatever research someone's doing in their field. Publish, keep publishing, go to conferences, network at the conferences. And it's funny because during the pandemic now, I think it's easier to network because I can go to conferences all over the world.
Right.
I don't have to travel. I just log in, and usually they've got networking events at all the conferences too, and people will show up who never would have shown up. They may be from other countries, other continents. Um, so I think that's important. I also have a few things that I think are, for me at least, are important. I always embrace whatever presents itself. I like the lawyers to know that I don't try to force an outcome of an analysis. Whatever it is, that's what it is, and so that's one.
Yeah, but before you move on, let me ask you about that. Have you found yourself in situations where you have felt pressure to say that the outcome of an analysis is X, Y, or Z?
Well, the answer is both. I have had times where a lawyer will want me to have a particular outcome. Obviously, I won't do it unless it turns out that their desired outcome actually was the one. But I have had attorneys where they want me to find a certain way, and if the data supports it, that's great. But that's a boundary that I don't allow a client to cross.
Are you aware of those issues going in? In other words, can you kind of tell from the outset if that's going to be a thing, or is that something you've had to deal with that you find out after you've conducted an analysis that it's not going the way that your engaging attorney wants, and they want you to either redo the analysis or change the numbers or something?
Usually one of two things happen. So one is the attorney doesn't necessarily have to incorporate all of my opinions. And so for me, if it's something I deal with, sometimes I don't find out until afterwards, and I say, this was part of what I found. I don't see it. Well, we decided that, and, well, they don't have to, cite all of my opinions. More commonly is that it's on the other side, and that I'll look at an analysis and an opinion. It's just something that you can sense, like, okay, the lawyers told him or her this is what they need to conclude, and then they find some weak or beyond circuitous logic, and I'm thinking, why? And it's like, oh, I know. Actually, I had one case that was really interesting. I was a neutral, and one of the sides presumably knew what the result of the analysis was because they had the data too, presumably.
Okay.
It wasn't favorable for them, but it did require a very creative analysis. So maybe they didn't know. Maybe they didn't. I can't. I'm not an expert psychologist. So
Right.
I don't try to figure that part out. But those are the main cases. My lawyer not using all of my findings, or realizing the other side. Oh, they were forced to come up with an outcome, and they found something that would support it. Usually those have been pretty straightforward to oppose.
When you're engaged as an expert, are you typically or sometimes put on a team with other experts?
Sometimes. My field being statistics, the answer is I'm almost always engaged with someone else, but it's not necessarily another expert witness, because maybe the data came from a corporation. Corporation has some data and they send it to the lawyer, and then I have it. But sometimes there will be other experts involved if it turns out to be a product that it's important also the product. So for example, if it involves baby food, I'm not an expert on baby food. I'm an expert on the data that's related to analyzing how to do sampling and how to do surveys. And so really for any product, of course, but maybe there's something characteristic about the product that's important, whether it's medically related or food or that can happen. One came up that was critical with prenatal testing. There was an error with a prenatal test. And of course, I interacted actively and often with the MD.
Sure. When you are working alongside other expert witnesses, what's that relationship like? Is it collaborative, or are you pretty much staying off doing your own things? How much interaction is there?
It varies. There have been times where there is interaction, and it's a difficult thing because I don't want to overstep my boundaries. And sometimes there can be an overlap. Like, for example, I'm a statistician. Maybe I'm collaborating with an economist. So there's some overlap, and I do know an awful lot about the things that fall in my domain. On the other hand, I don't want to tell the other expert what to do or what, because that's not my place. So there's a balance.
Does the attorney themselves set up kind of the framework for that? Do they say, oh, I want you two working on this, or I don't want you two talking about this, or something like that?
My experience is yes, it's been set up by the attorney. Usually it's very clear, but not always. I had one case where the lawyer said, yes, talk to this other expert. And then they said, oh, you weren't supposed to talk to the other expert. Well, I, what am I supposed to say,
Right. I guess there's not much that you can other than, hey, you told me that already.
But
You've worked for both the plaintiff and defendant side. What are some of the differences?
so and thankfully I've also worked as a neutral. So I've been on all three sides. One of the differences I note is that if it's dealing, as it typically is with corporations, a defendant who's a corporation is very, at least my experience, has been more focused on the monetary outcomes. And a plaintiff, which is, let's say, a plaintiff that is not a corporation, they're typically more focused on the personal aspects of the outcome. So, for example, in disability, Social Security disability cases, there could be someone, it's a real human. And it could be
Right.
someone who could be someone who has disabilities, challenges, hardships. It's a very personal thing. Yes, there's the statistics and the data, but the outcome is really, really, really important on a very personal level. And sometimes I get the privilege of working with attorneys who, if they're not exactly working as pro bono, it might be very close to it. And so the attorneys are also very sympathetic too. So that's a typical, but probably most are somewhere in between. The lawyers don't want to spend millions of dollars if they're not going to win the case, even if it is, okay, people who were discriminated against or, weren't paid properly, but they also have the eye on what their cost is.
Let's back up a little bit to the report writing process. Do you have any specific strategies that you employ in terms of either organization or collecting all of the mountains of paperwork that you might get from your attorney or anything like that?
Yes, and even before that, to talk about the various papers from the attorneys. Attorneys think through, at least my experience, they know which documents they want to give me. So I have had cases where the attorneys specifically do not want me to have a particular official document from the court. I don't question. Whatever they say is fine because it's their decision. And I did have one attorney very specifically. And that's how I learned not to even, don't worry about it. Um, they hadn't given me the complaint. It was a very high profile case, and they didn't give me the complaint. And I wasn't like, I thought they had forgotten. And I said to them, I didn't get the complaint. And the answer was very stern. If it's important to you and critical that you have the complaint, this is not a good match and we'll retain a different expert. Okay, don't give me the complaint. I'm all right. I don't need the complaint. I mean, I'm doing an analysis. Give me the data. I'll do the analysis. So I don't have the complaint. Okay, fine. Usually they give the complaint. But
yeah, that's a situation I haven't heard of before. That's interesting. I wonder what the strategy was there.
Yeah, so now I ask impartially. I tell the attorney, whatever documents you wish to send to me, please send. That's it. No discussion. They know. I'm sure they know what that it's fine. So okay. So that now in terms of organization, and this is something I actually tell my students at university, that they should have a template of directory structure on their computer. And for me, I call it template. And it has subfolders, data, output, programs, documents. And I have this structure. So when I get a case, immediately I start with that structure. And then that way I can handle, maybe they'll send me an Excel file, maybe they'll send me a document, maybe they'll send me a text file, whatever they send me. So I don't have to think about it. They send it to me, I put it where it's supposed to go. And then, of course, in writing the document, some things are always the same. My name, how many years, where I went to my degrees. And so I have that, and then I'm always starting with that. And so they match for all the cases in the beginning. And of course, after that, they're not the same. but
Sure.
But in the beginning, the same. And there, for me, and I don't know if everyone has this in their specialty, but for me, I always mention every data file I've received and every document. And it's early up, and maybe there's 30 different things I got. Maybe there are 5 different, maybe there are 2, maybe nothing, but whatever it is, I list it. And then I find it helps me too in my writing because I've got the list already. I know it's one of the documents. I can refer to it. I call it, reference 1 through whatever. And so I'm always able to refer. So that's a little bit about the structure and how I approach it.
Sure. Is there any difference in the strategy for when you're preparing an initial report versus a rebuttal report?
I would say in terms of the statistics, not really. And the reason why is this. I approach whatever the analysis is and whatever the data is, and then I'll be doing analysis. If it's rebuttal, I think it can be, I'd say my style, I usually like to show, no, the method given by the opposition expert is inferior or incorrect or replaced or made obsolete, whatever, by this analysis. So to that extent, no, I'm still doing an analysis. I'm still replying. Now, it is true. Sometimes maybe there's something, and I'll only need to limit it to saying, no, what was stated is incorrect, and this is why, and I may not have to actually do an analysis too, but usually I do.
When we first started talking, you told me that your first case, you were kind of brought in right in the middle of the process, and the walls were on fire, and you turned it all around. Typically, do you feel like you're brought in at an appropriate time and you have enough time to develop your reports and discuss strategy with your attorneys, do any prep work?
I'd say it's between about half the time. So it used to be worse. I'd say that the attorneys are getting, in my anecdotal experience, they're figuring out they could benefit from a statistical expert sooner than they used to. But the other half of the time, no. I mean, like with, I don't know, there would have been an opportunity with my first case, but obviously I could have benefited from more time. But it didn't really matter because I was able to figure out, in that case, it when they gave me the materials and I read through it, it turned out that the other side had redacted computer code, but they didn't use the word redacted. It was the old Xerox copy day. And I was looking and it's like, I think they covered something up here. I think I think there's something underneath, like a sheet of paper that's covering up something. And I was able to derive that there was something missing. Sure enough, that's what it was. So, if I had more time in that case, it probably wouldn't have mattered. But when it does matter is I had a case where I was given hundreds of Excel files to analyze statistically. And each of the Excel files had 100 sheets.
Oh boy.
And I was given, I think it was about a week and a half. Yeah. It brings up something that I learned. Everything was eventually fine. But sometimes on a deadline, I did learn it's a really good idea to talk about hours that are expected to be put in. If someone gives me a case, which probably I should have had about, let's say, 200 hours to prepare, and I have a week and a half, I don't expect complaints about putting in every available hour that I can possibly do. But sometimes there can be a misunderstanding. So if it's very late, I've learned make sure that they understand that the compressed time still may require a lot of hours. And just so they know and that they're not surprised, and to clear that up. When it's late in the process, thankfully, usually it's worked out okay. But half the time it's very compressed.
Absolutely. As you know, there's a couple types of expert witnesses, or really a couple types of engagements. You can be brought in as a consulting witness. You can be brought in as a testifying witness. You might end up doing depositions. You might end up in front of a jury. And sometimes you don't even know. You have a pretty extensive career, so I imagine you've been in all of the above situations.
I have, and I add to this that we're in a pandemic era, and so all the things that I may have grown accustomed to before the pandemic are different now. So I prefer Zoom. They're and also thankfully, almost all the cases have resolved before trial. So there always were very few court appearances, thankfully.
Okay.
Thankfully. But they did exist. And now, even then, there's almost always the option of being on Zoom. So, in terms of what happens, and, I don't think the lawyers always know, yes, you're going to have, the standard way used to be write a declaration, have an interrogatory, you know, dump out all your emails and computer records, have a deposition, get a response from the other side, reply to it, and it was like that. I don't see that as regularly now. Maybe it's a function of being called in later recently. I don't know. As I said, but the things about being in court, thankfully, unusual.
Even though you're not in court, you still have some of those similar functions. You might have a virtual deposition, for example.
Oh, yes. I'm not sure that the change would be because of being on Zoom or not. But I will say that there was a difference before and after I got my master's degree. Before I got my master's degree, and of course, there are plenty of expert witnesses in whatever field that have a bachelor's degree, they don't have a master's degree. Okay, fine. So I was in that category at first. And I found that all the depositions, literally for a half a day, which personally I don't care. I don't have anything to hide. I talk about my background and I talk about my opinion, and I'm patient with it, and not to get on the defensive. So it's fine. And so I knew it, but it really was 4 hours every deposition, basically underneath it saying, you don't have a master's degree and you're claiming that you're an expert. The unspoken question. But that was what it was. And okay, fine. So I did notice that after the master's degree, those questions vanished. And by the way, it always was favorable. There was never a case where they said, no, you're not an expert. It was always
right. The academic credentialing, though, does give you some gravitas, so a little leg up.
It does. I think what they, I'm not an attorney, so I can't totally speak for them, but I think they realized there's no purpose to that, like trying to say, well, you don't have a Ph.D. or you're not a Nobel laureate or you're not, fill in the blank. They realize there's no purpose to it. I'm an expert. That's fine. And so they start off. They'll ask about, where I got my degree. I think because they're interested. But then they go to the material.
Do you have a couple of interesting cases that you can tell me about that kind of have either changed the way that you approach expert witnessing or have been important to you in your career?
Yes. So one of my early cases was for a plaintiff against a retail company. And it went on for a couple years. And I could perceive that even though my opinion was that it violated, statistical opinions that it violated labor code, and I did my analysis, an elegant one. Actually, it was a very advanced analysis. I did regression analysis on the various data, but I could perceive that the other side seemed they just didn't hold my opinion. That's all. But they seemed to be, really, a good firm. And okay. So after a couple of years, the case resolved favorably for my client. And the defendant, I was on plaintiff's side, the defendant contacted my attorneys and said, we really like Dean. We like what he did. We like his analysis. Can we retain him for our future cases? Will you release him to us? And so my lawyer did. And to this day, the other side is a client on the side of defense.
That's amazing.
It really was, and it is. And one of the things, beside it being a very kind sequence, is that I learned it's very important to be on both sides, and additionally neutral if the opportunity, because then I know what I would critique if someone presented my analysis, because I've been on the other side. Whatever side I'm on, I've been on the other. So it really helps, and I think it increases the quality. So that certainly is one case very memorable. Another case that was an international case. It was with United States attorneys, but the defendant was a Portuguese cork manufacturer where the cork is used for wine.
Okay.
Now, there's an issue of wine getting tainted, which in the industry I learned it's called corked, because there is a chemical called TCA, and I'm also a member of the American Chemical Society. I'm a fellow in the American Institute of Chemists, so I like things that are with chemistry. And generally speaking, at that time, if 4% was considered the maximum acceptable percentage of tainted wine bottles. If 4% were bad, that wasn't great, but it was okay. So the plaintiff had an experience where they had an international tasting and the bottles were tainted and they did suffer a lot of loss. So the question was, from their perspective, it was the fault of the cork manufacturer because they're the ones that caused the corking. Well, that's where the statistician came in, and boy, was I called in at the last moment. They literally were about to lose, literally, like days later, and they said, if you can help us. So that was one where I had, I think it was 3 days, maybe it was 4. In fact, I remember I did a lot of the analysis on a train going up to see the attorneys on my side, and then get deposed. So what happened was this. The wine manufacturer said that 1 of 12 cases were tainted, which would be over 8%. And
Right.
that's why the defendant was about to lose. There is no defense. If it was 8% and the acceptable at that time was 4, done. So I examined the process by which the wine manufacturer analyzed their cases. What they did, because they weren't statisticians, they would keep track by the case. So I think they had 144 cases and 12 of them were tainted. And I looked at the data, and I realized this is by the case, not by the bottle. And so it was consistent with 1 bottle in that case being tainted. It wasn't 12, it could have been 1. They didn't keep track. I don't know why they didn't keep track, but they didn't. So when they deposed me, I said, it's consistent with not 12, all 12, it's consistent with 1, which not only would have been less than 1%, 1/12 of their estimate. They settled the case the next day.
Wow.
So, yeah, so those are 2 cases that come to mind.
And you said this was an international case.
It was, and it may have been my first international case. It was international because the cork manufacturer is in Portugal. So even though the lawyers were in the United States, the defendant was in Europe. Now, since then, I've had thankfully, many clients as a consultant in Europe and Japan and Hong Kong, and I've had expert witness cases in Hong Kong as well. And one of the things that's different now, maybe because I'm a statistician and I deal with data, but it is important to note that the data is stored in foreign languages. And foreign languages are not always read properly, even by statistical software.
Sure, like commas and periods are used as different separators in different countries.
That's right, and it can get even more so that a digit may not even get recognized at all because they write their digits differently, and maybe it's a special character, and so there are different things that are very special to different languages. And if one's not looking at data, certainly, when you're looking at documents, it isn't always in English. Maybe it's in French, or or um, so that's another aspect. Yes.
Is there anything else that is, strikes you as um, different about working in different venues? In other words, when you're working either for somewhere in another country or another state or even another county, there's different laws, there's different frameworks. Is that something that concerns you as an expert witness, or I guess as a statistician, or is that something that largely doesn't impact your work?
So starting from the statistics point of view, I analyze data where, I don't say, oh, that's French data, I'm going to analyze it differently. No, that part's the same. But for example, let's take labor law. Well, I've had several times where knowledge of Belgian labor code could have been important. And of course, it's completely different. Same thing with British. I had a potential case where it was someone in the United States doing a project for a company in Paris being paid by a company in England. And it was a little tricky to know which labor law applies, which employment law applies. Someone, if they're, 40 is the important age in the United States, but it isn't that number everywhere in the world.
Sure.
Overtime is another one. Even within a state, of course, there are distinctions of what employee gets overtime, but all of those are different state to state. Some of them are different city to city. In California, for example, there are different minimum wage applicable in different cities. And then depending on the year, maybe the different size companies. So same thing with Europe, same thing with other states. So yes, so when you do the research, I got a couple textbooks on international labor code. I got one on just Belgium, and you learn, and you learn.
So you find that for some of these cases, there is a little bit of additional research that you need to do prior to, say, writing your report.
Well, in my case, that research I didn't bill, I didn't invoice, I didn't feel, they were retaining an expert, and if I needed to learn about international labor code for a case, I didn't think it was. I thought that was my education.
Interesting.
But there certainly would be cases where it would be uh, billable. Uh, if it's something that more extensive, or it really is. There could be cases where it's different, and if I felt it was something to that was invoiceable, I still would talk about it first. Like, yes, I'm an expert, but this is what I don't know, and and I don't think I should be responsible for having known it. And so, what should we do?
Right, right.
That has not happened. I'm not sure. That would be something I'd really have to think about to say, no, 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 that this is a special request by the attorneys, and it's their responsibility, not mine.
Before we wrap up, I'd like to hear your opinion on kind of just the general relationship between experts and attorneys. What are the things that make a positive engagement? What are the, some of the engagements that you've worked in that you've really had a great experience with, and that you wish other attorneys would do, or that other experts should be doing to have, a positive, successful engagement?
There are a couple things that I hold very close to me as a human. and as an expert. So one is to avoid anger and arrogance in general, avoid it. And the other is to help animals and humans. Now, those two things may not sound like expert witness sort of material, but when you say when is it that there's the best relationship with the attorneys? I think when they overlap with those core essences of myself, then that kind of um, transcends everything. Because, the profession of being a lawyer, it's different than being a statistician. And yes, there can be times, like I will say, that I've been with had lawyers who are interested in various research, and I've consulted them on their research. And of course, that always is nice because I love research. But really, underneath it all, it's really the essence. That's really and I can tell if I think, I hope I can tell if that isn't what they're looking for. It's not that I reject them. I don't mean that at all. But you're asking, what is it that fosters the best relationship? And I think it's
Yes.
that it's not anything specific with the profession. It's the essence of the human.
That is some very wise words and some sage advice. Mr. Barron, thank you so much for joining me here today.
A pleasure, a pleasure.
And thank you to our audience for joining me for another discussion at the Roundtable. Cheers.
Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.